Uh, Today we're going to be going over this case about the appellate court for Tina Peters, and it's pretty interesting. Let's watch again. I don't want to watch again. Yeah, I do kind of want to watch it again. But all right, so let's get right into this, and we're going to replay a little bit of it. Then I'm going to go over a little bit about what happened to Tina Peters. So let's get right into this.
Is it your position that a person can still be convicted of a crime with which they were never charged and with which the jury was never instructed, as long as the evidence is sufficient?
Yes, I think that is what the case law indicates, that it's just, in this case, I'll just point out too that, I don't have the language of the statutes that you're citing in your hypothetical, but it was one word, might, and it was already...
Yeah, but that one word distinguishes it from a felony to a misdemeanor.
And this case made an extra sentence, 15 more months in the Department of Corrections that couldn't have...
Okay, so one word might. She used the word might, and that added a felony charge because it just did. And so it added 15 months to Tina Peters' sentence because it changed it to a felony instead of a misdemeanor. It's nuts.
Been given had it been a misdemeanor conviction. It clearly affects a substantial right.
And I'll just say, I'm confused as to why the people are continuing to maintain that the proper remedy on this isn't to enter the conviction for the misdemeanor, because the indictment used the word might, and the jury wasn't...
It should be entered as a misdemeanor. It should not be a felony. In fact, I don't know why it's not a mistrial. But I'm going to take this moment here, and we're going to go over just the basics of what Tina Peters was charged for and what happened to her. So, in my opinion, corrupt Colorado Secretary of State Jenna Griswold led the case to Tina Peters' suspension, criminal charges, and a 2024 conviction on 7 counts, including attempting to influence a public servant, conspiracy to commit criminal impersonation, and official misconduct. Sentenced to 9 years in prison, she remains incarcerated while being viewed by supporters as a political prisoner and by critics as a threat to election integrity. Now, we'll go right back to the case here.
Instructed on that, so that's what the verdict is. I am baffled as to the position that's being taken that we can somehow overlook that and still enter the felony because the evidence that was presented at trial would have supported the felony. Are you still maintaining that position in front of us here today?
Yes, that is our position.
What case law supports that argument?
I'm sorry?
What case law supports that
I've
argument?
cited it in my brief. I don't have it right in front of me, but the case...
It's the omitted elements
Yes,
case
right.
law, right? But that's just where the element was omitted, and but the element that was omitted wasn't in dispute. Here, the jury was affirmatively misinstructed. It was instructed on the misdemeanor, and it found her guilty of that misdemeanor beyond a reasonable doubt. This isn't the omission of an element. This is a misinstructed jury. How can we correct that by saying, no, we'll just assume?
Yeah, so this misinstructed jury, should that not be a mistrial? I mean, when the prosecutor messes up and the jury essentially sentenced Tina Peters for a felony instead of a misdemeanor.
That because she could have also been convicted of the felony, we enter that even though we don't have a jury verdict. That's a...
I understand it's a difficult position
Okay.
for the people to be in. But
It's not a position you have to take.
But thank you. But I do believe that the omitted element language applies because, to me, I understand. I can hear from the way you're talking about it that seems more egregious to add this extra word than it is to omit an element. But to me, omitting an element is a pretty big deal, and the fact that can be
Except in those cases, at least the person was originally charged with the elemental language. Here, never on the table.
She was never charged with the felony. but yet she got convicted for a felony.
That is true, but if I can just add, and again, it seems that I will not be able to convince you, but I just want to put my argument out there, which is that there wasn't a confusion from the parties about what they were talking about, because the correct statutory citation was used. So they were on notice of the statutory citation. The language was incorrect, but the statutory citation was correct.
Couldn't that also mean that the prosecution was on notice that they'd only charged, since the language was correct, they'd only charged that language and not,
Well-
I mean, both of them were on notice of something wrong.
Oh,
And he points out something really good here. Both sides were aware of something was wrong, but she proceeded knowing it was wrong, knowing it was a felony, and knowingly misled the jury. That's the difference.
yes, I guess what I'm saying, Your Honor, is just that there wasn't a notice problem because there was the statutory citation, and the parties treated it as though
There wasn't a notice problem between the parties, between the sides, but there was a notice problem to the jury.
I think it was an oversight. I think everybody believed that they had charged and used the language for that's what the record bears out, in my estimation.
Okay, so that's the end of the clip there. I think it should be thrown out. I think it should be time served. I think Tina Peters should be able to sue, and I think she should be disbarred because she knowingly misled the jury on felony charges instead of misdemeanor charges, which Tina Peters was not even charged for. All right, what do you think? Let me know in the comments below. You guys have a nice day, and I'm going to wrap this up right now. Thanks, guys.